Thank you very much. My name is Marty LUECK. I'm the chairman of the Robbins, Kaplan, Miller & Cerisi law firm based in Minneapolis, Minnesota, with offices in New York, Boston, Atlanta, Los Angeles, and Minneapolis. And it's my pleasure today, first of all, thank you for having us. It's my pleasure to introduce my partners, but before I do, let me just acknowledge that the hour is late, and we will try to be both energetic and entertaining in our presentations. And in my case, I will try to be relatively brief, which is always a challenge. So let me begin by introducing my partners who are here with me, and I'm going to start with Brian Vogel. You can either stand up or raise your hand. Brian is a partner in our New York office. He is a very experienced patent lawyer and litigation and trial lawyer. He has experience in the Patent and Trademark Office. He's very involved in the Federal Circuit Bar Association. 2 times he's been recognized by the Federal Circuit itself as a leading member of the bar in pro bono activities. We're very proud of him for that. This summer I had the pleasure of trying a case in the International Trade Commission with Brian, which is also one of his specialties. Seated to his left is Matt Woods, and Matt also, he comes to intellectual property late in life. He was an antitrust lawyer first, he still is. Matt has the distinction of having represented Honeywell recently in recovery of over $200 million in a case which involved a single patent, and it was a patent that Honeywell was not practicing at the time the suit was brought. That case was in Delaware. More on that theme later. And then, Bill, if you would stand up. Our partner, Bill Manning, who is one of our most senior trial lawyers in the firm. Bill has had a very long and distinguished career in many areas of the law. Before he joined us, he was the head of the civil division for the Attorney General in the state of Minnesota, where he was a very well-known tort lawyer. He's continued that practice. More recently, he has been an extraordinarily successful attorney on behalf of plaintiffs seeking to recover very large amounts of money on their patents. And that's what he's going to talk to you about today. I haven't been at the conference a long time, but I'm struck by a couple of the themes that I have seen emerge. And what I have seen here today in particular reminds me a lot of what it was like to begin practicing patent law in a litigation and trial setting in the United States in the 1990s. Our law firm started in 1938, and there were no patent lawyers or intellectual property lawyers of any sort in the firm. Instead, it was a law firm that specialized in trials. And it's still that way today. We have 250 or 260 attorneys. They are all dedicated more or less to trying lawsuits or handling litigation of one sort or another. And of that 250 lawyers, probably 90 to 100 of them are engaged in intellectual property litigation. If you go back to 1993, we did no intellectual property litigation. And it was partly through the efforts of Bill. Our client at the time, Honeywell, who we didn't do any IP work for, was using a traditional patent firm in the Minolta case. And there came a point in that case where clearly there was a need for some more experience in the trial arena. And Bill saw that opportunity and put our partner Michael Cerisi in front of Honeywell. The result was a verdict in favor of Honeywell of nearly $100 million in New Jersey, and later on the subsequent licensing of nearly the entire autofocus camera industry for well over $500 million. Now, I mentioned that from a couple of perspectives, and I'll go back to the point that I made just a couple of minutes ago, why it reminds me to be in the place that I see here today going back to 1993 and 1994 in the United States. When I said tipping point in that case, it was a tipping point more than one way. It was a tipping point within the case itself, certainly, but it also was a tipping point, I think, in terms of how corporations viewed the potential for patents to be very powerful drivers of bottom line revenue. And it was a tipping point in one other area. It was a tipping point because it was the first time a general practice trial firm like ours had ever gotten involved in what was really the bailiwick, or the province, if you will, of dedicated patent firms in trying patent and intellectual property lawsuits. Now, here's what happened in the succeeding 3 years after that. We, of course, gained a great deal of notoriety as a result of that verdict. Shortly after that, another partner of ours, Ron Schutz, and myself tried a case against General Electric in Long Island in New York for the inventor of magnetic resonance imaging technology. That resulted in a $110 million verdict against GE. As an aside on that, at one point, Ron and I, at the ripe old age of, I think, 37 and 38, sat down alone with Jack Welch and tried to settle the case. We sat in his office in New York City. We had a very pleasant talk. He offered us $80 million. We politely rebuffed him, and he said, maybe you don't understand what I'm saying. I'm going to write you a check for $80 million. I'm going to sign it. You're going to put it in your pocket. You will be the only people walking on the streets of Manhattan with $80 million of my money in it. And we thanked him. We left. We got 128.5. A couple of years after that, Mike Cerisi and myself tried a case for Union Oil against virtually the entire refining industry in Los Angeles, California, over reformulated gasoline patents that Unocal had successfully prosecuted when California decided to go to its Air Resources Board low emissions gasoline. It was Unocal that really solved the riddle of how to make that gasoline burn cleaner in cars. We convinced the jury there to award 5.75 cents per infringing gallon of gasoline sold in the state of California during the 8 months of a year that gasoline had to be sold. Forward into 2000, I represented the University of California and its startup company Eolus against Microsoft over the feature in the internet browser which allows the browser to be interactive. That was, as you can imagine, a very hard-fought battle. We had a verdict of $520.5 million in Chicago against Microsoft. And then, to close the loop, the beginning I said in Minolta, and I'm going to tie all this up with why I think it's instructive in a moment, but I said we licensed nearly the entire industry in the autofocus cameras in the mid-1990s. There was one holdout, JVC, who Matt and I represented Honeywell against in St. Paul, Minnesota, and were fortunate enough to get a verdict of $30 million. Now, what does this have to do with what's taking place here today and over the last number of days? Well, it shows a few things. Number one, I think India and many countries in the world that are beginning to really realize the fruits of industrialization, the fruits of modernized business practice, systematized approaches to business, are really at that same inflection point that the United States was at with IP law 20 years ago. Second, I've heard a lot of people talking about how do you gain value out of your patents? How do you drive some value to the bottom line? Honeywell versus Minolta. Honeywell did not practice the patents at issue. The Fonar case, Fonar did practice its patents, but they had been squeezed to be very, very small in the marketplace by industrial giants like GE, Siemens, Philips, Toshiba, Hitachi, all of whom we successfully sued. Unocal started out practicing its patents, but then they decided it would be better to sell their refineries. At the time we went to verdict in the Unocal case, they didn't practice their patent. Aeolus and the University of California versus Microsoft. Again, trying to compete against a behemoth like Microsoft, Aeolus never was able to get a commercial product off the ground, didn't practice its own patent. And finally, the Honeywell JVC case, again, Honeywell didn't practice its own patent. So what you have is a succession of organizations that have been able to look at their intellectual property portfolio and find those places where there is tremendous value to others in employing technology that they have invented, even though it may not fit within their own business plan. And that is something that this firm has done for many years. It's how we put ourselves on the map in intellectual property litigation. And it's why today, and I'm not going to talk any longer, as you see Matt, Brian, and Bill present, it's within that context of having been really at the very beginning of these large patent damage explosions and lived through that big acceleration on the hockey stick part of the curve that has put us where we're at. So, Bill, take it away.